and welcome back. You're listening to Passing the Baton. I'm Jared Hight from Tracktown Law, and today we're going to talk about irrevocable trusts. Now I get it, irrevocable isn't exactly a word that invites warm feelings. It sounds permanent, unyielding, like you're signing away your legacy with no takebacks. And that's not entirely wrong. But when used correctly, an irrevocable trust can be one of the most strategic tools in the Oregon estate planning toolbox. Before we get into it, the usual disclaimer: I am an attorney licensed in Oregon and Idaho, but this podcast doesn't create an attorney-client relationship. And while we're talking about legal concepts, none of what I say today should be taken as specific legal advice. For that, please schedule an appointment with someone who knows the details of your situation, preferably someone like me. Let's start by understanding what an irrevocable trust actually is. In contrast to a revocable living trust, which we covered in episode 11, an irrevocable trust is one you can't easily change or dissolve. Once you create it and move assets into it, you no longer own or control those assets directly. A trustee manages them. You've given something up, and in return, you get legal separation that can open doors for asset protection, Medicaid planning, tax mitigation, or legacy structuring. So why on earth would anyone want to give up control of their property? Let's walk through a few scenarios where it makes real-world sense. First up, Medicaid planning. As you may know, Oregon Medicaid has a 5-year look-back period. That means if you apply for long-term care assistance, the state will examine your financial transactions over the previous 5 years to see if you gave anything away. If you did, say you gifted your home to your kids, that gift can delay your eligibility for benefits. Enter the Medicaid Asset Protection Trust. This is a specialized, irrevocable trust where you can transfer your home or other assets, retain the right to live in the house, but no longer technically own it. After 5 years, it's out of reach for Medicaid calculations. That means the house can be preserved for your heirs rather than sold to reimburse the state. The catch, of course, is that you need to plan well in advance. This isn't a strategy you roll out after the diagnosis. Another use case is protecting an inheritance from creditors or bad decisions. Say your adult child is financially adventurous. Maybe they're in a shaky marriage, have business debts, or a track record of investing in things like alpaca farms or vintage vending machines. You love them, but you don't want their inheritance to vanish because someone else got to it first, or because they made one bad decision too many. An irrevocable trust allows you to leave money for your child in a way that's managed by a trustee with specific distribution rules. The child benefits, but doesn't have direct access, and more importantly, neither do their creditors. In Oregon, we can't create a self-settled trust to protect your own assets from your own creditors, but you can use irrevocable trusts to protect others from themselves. And sometimes, that's the most generous move you can make. Now let's talk about special needs planning. If you have a loved one who receives public benefits, things like SSI or Medicaid, a direct inheritance could disqualify them, even a small one. And that's where third-party special needs trust comes in. It's irrevocable by design and allows you to provide financial support for that person without affecting their eligibility for the programs they rely on. The trustee can pay for supplemental needs, housing upgrades, transportation, recreation, things that public assistance doesn't cover, while keeping them safely under the asset and income limits required by law. Then there's tax planning, which gets more complicated in Oregon than people realize. Remember, our state estate tax kicks in at just $1 million. That includes your house, your retirement accounts, your life insurance if you own it, pretty much everything. One classic tool is the Irrevocable Life Insurance Trust, or ILIT. You create the trust owns the policy, and when you pass away, the death benefit is not included in your estate. That can make a significant difference, especially for folks who are asset rich but cash poor. For married couples in Oregon, the state's $1 million estate tax exemption comes with a hidden trap. It's use it or lose it. Unlike the federal system, Oregon does not offer portability, meaning if one spouse dies without using their exemption, it's gone for good. A credit shelter trust, sometimes called a bypass trust, is an irrevocable trust designed to preserve the first spouse's exemption by sheltering their share of the estate. When the first spouse dies, their assets are placed into the trust, the surviving spouse can receive income or limited principal distributions, and those assets are excluded from the surviving spouse's estate. The result is that each spouse gets the full $1 million Oregon exemption, reducing or even eliminating estate tax entirely for the couple's combined estate. These trusts are what are called testamentary trusts, and they are created at the time of the first spouse's death as a provision of that will. And while they do restrict how much flexibility the surviving spouse has, they can be tailored with built-in discretionary language, including the HEM standard, which we'll cover in the next episode, to allow for reasonable access while still achieving tax savings. If your combined estate is even close to the Oregon threshold, a credit shelter trust is often the difference between passing on your wealth and passing on a tax bill. Now, I should mention, irrevocable doesn't mean inflexible. There are ways to build in guardrails. You can reserve certain powers, including limited powers of appointment, or use something called a trust protector, a neutral third party who can make modifications if the law changes dramatically or if the original purpose of the trust becomes impossible. That's advanced level stuff and it needs careful drafting, but the point is, irrevocable doesn't mean set in stone and forever doomed. That said, there are trade-offs. You're giving up access and control. The assets in the trust don't belong to you anymore. You'll probably need to file a separate tax return each year, and depending on the type of trust, the tax rates can be higher. You also need to choose your trustee wisely. This is someone who's going to be holding the pen on decisions that matter. It's not a light decision, but it is a powerful one. Used correctly, irrevocable trusts can shield assets, preserve benefits, protect your legacy, and give you peace of mind that what you've built will go where you want it to go on your terms. In episode 14, we're going to talk about a concept you'll see in nearly every irrevocable trust, the HEMS standard, HEMS, that stands for Health, Education, Maintenance, and Support. It sounds like boilerplate, but it's not. It's the legal language that determines how much discretion your trustee has and how much protection the trust really offers. If you've got a trust or you're thinking about one, this next episode is worth your time. In the meantime, if you're wondering whether an irrevocable trust belongs in your estate plan, or if you just want help figuring out whether you've already got one without realizing it, head over to tracktownlaw.com and book a free consultation. I'll help you cut through the complexity and get clear on what works, what doesn't, and what might make sense for your goals. Thanks for listening.